available. Then try it more. 2, 1, 2. It was really sensitive, wasn't it, the other day? But it's not the correct level. Yeah, that's the one that in the court, everybody wearing headphones in court will we're fine. So that's through this system, two systems. Yeah, yeah, court to understand is fine. It's the broadcast. Right. I've taken out the water, I take it out, but
I was going to address in particular two questions this morning. The first question about the reason why we say that an meaning must apply to the Welsh phrase addas, this, sin addas. And I was wondering whether I could come to that as I deal with the remainder of my submissions on ground 2 in just a moment. And therefore address first of all the question just Lewis posed in relation to the redundancy of the phrase meaning. That's okay. Yes. Let me say straight away, we do accept that if the phrase any weren't there, then the meaning would effectively be the same. It would be wrong to suggest otherwise. It does serve, we say, to emphasise. It could have been made clearer, and I'll take your lordships to other provisions in the Act which show that. But I think the point that my learned friend made was by reference to Fenian in particular, but perhaps we could turn this up now. It's tab 23 of the authorities bundle, section 21.2 of that. It is to turn of pages 511 to 513. I think in the electronic bundle it's page 676. I'll double check that this morning. So we see the well-known principle proposition that 21.2, there is a presumption that every word in an enactment is to be given a meaning, but it's clearly not without exception.
Which paragraph precisely in Benny? 21.2.
21.2. Under the commentary, under the heading No Sensible Meaning in Surplusage, your lordship see this is on page 512 now. The paragraph which starts every word cannot be given a meaning. Continue if there is a deliberate tautology of the words are unnecessary for some other reason.
So could you just give me a second?
Of course, my lord, just There are advantages for this now.
To rise from
All right.
Testing. Can you hear me clearly? Is this clear? As clear as it needs to be? Great, thank you very much. The bit-in section starts at internal page 511. I think it's 6. Having set out the principle at 21.2, I was taking your lordships to, as is under the comment on page 512, the next page. Every word, about 2/3 of the way down, every word cannot be given a meaning if there is a deliberate tautology or if words are unnecessary for some other reason. Walker inspector of taxes against simple clothing, and went so far as to say, I seldom think that an argument from redundancy second heading example, reference to the Mobile Homes Act, 1993, which states, the owner shall be entitled to terminate the agreement forthwith if, on the application of the owner, the court is satisfied that. It was sought to give a special meaning to the italicized words, which is Norse, holding that the word was given the ordinary meaning, said, it is perfectly true that if that is the only function of the words, they could just as well have been omitted. If a long experience of legislative drafting had brought with it a conviction that an Act of Parliament never included words of surplusage, that would no doubt have been a persuasive point, but that is not our experience, and I for one do not complain of it. An emphasis of the obvious and necessary to a judge who has the benefit of argument, may yet be welcome to a busy practitioner who has not. My submission is that's precisely what it is. Yeah, the words are not absolutely necessary. And that does not mean that they do not carry meaning, and it is the meaning that we can do. Now, in order to understand the difference of the Welsh text brings, I want to take lordships first of all to what the appellant says in relation to the English text. This has been a common part of its case, and set out in its skeleton argument for the hearing at the first instance. That's at tab 11 of the core bundle, paragraph 27, 167 of the core bundle. And there you will see the proposition that it does not matter at all for these purposes where the word only is placed within the phrase, following the word school in section 52A. The phrase would on any sensible have exactly the same meaning whether it read, and then there are four versions. There's
paragraph you're at in that
27. Yeah. It is repeated in the appeal schedule.
I want to see the first bit.
Yes.
Sorry, which page is that?
167.
167.
Yes, the phrase would on any sensible have exactly the same meaning whether it read. Firstly, only providing education suitable for the requirements of persons above compulsory school age, or two, providing only education suitable to the requirements of persons above compulsory school age. We say that those two things do more or less mean the same thing. Then the third one is, or as in this case, providing education suitable only to the requirements of persons above compulsory school age. And we say that is different. The only there is qualifying different. Or indeed as the claimant contains in respect of the Welsh version, providing education suitable to the requirements of persons above compulsory school age only. That doesn't make sense very much in English, and it's an attempt to render the word order in the Welsh. But what the appellant said, and still says, is in paragraph 29, the above points also disposes these case on the Welsh language version of section 52A, since it does not matter where in the relevant phrase the word only comes, it does not matter where an enig appears either. And it's that we say is simply grammatically wrong. In the Welsh language version, which we can turn that up in the authorities. Started in tab 5. We say the corresponding phrase meaning qualifies and can only qualify the clause addys sy'n addas at anghenion personau sydd dros oedran ysgol fodol. That is, education which is only suitable to the needs of persons who are of a school age, that of course is sixth form education. So that's effectively the appellant's version 3 in the original scale. Importantly, the Welsh version does not read sy'n darparu yn unig addysg sy'n addas at anghenion personau sydd dros oedran ysgol fodol. Now that would be the Welsh equivalent of the appellant's versions 1 or 2.
didn't want it. But that would have the same meaning as what I just read out. The point we make is that 1 and 2, at least in Welsh, we say in English too, 1 and 2 have a distinctly different meaning from 3. And that's as a simple matter of interpretation of the wording of the statute in Welsh. If the proposal is to discontinue sixth form education at a school, regardless of whether the proposal has any effect on any other compulsory education at the school, it will fall squarely within section 52A and therefore 51.
The problem that I've got, I understand that an English qualifies in others as Angahynion, but in others Angahynion qualifies as Scot. You start off, as I said, with a proposal as Angahynion, you said that you need to run the Scot, and thereafter, everything that comes is explaining which schools are for. So whether you put an English anywhere in the qualification, ultimately, will end up being applied to the thing that the school is providing.
Well, no, because if an meaning only belongs to the later clause, then if a school provides education which is only suitable for age, it could be a comprehensive school which has a sixth form, because it would, as well as providing good education, provide education for those above the cost of school age.
Perhaps the problem with that is it really does give no purpose for needing down. Back to your first question. Well, much more likely they were trying to explain which schools were for. And although they haven't done it elegantly, what they're trying to get at is a school for everybody, which does one thing and one thing only, providing education for those above 16.
Certainly in Welsh, it emphasises that if a school provides education for sixth formers, it's covered. That's the heart of its mission. So that it does have common sense here. Perhaps if I can take you, Your Lordships, to why we say that. As a matter of Welsh grammar, it is the position of the word "enig," but it's also that they are at the end of and in a separate clause. That is important, and not the clause ysgol sy'n darparu. That's unlike the English version, which of course isn't divided into clauses. The qualification of the adverbial phrase, therefore, meaning we say cannot, as a matter of syntax, apply to ysgol sy'n darparu, the school which provides, it must apply to the later clause. Now, best explain that, you can look. I thought I'd be in this position, but for a Welsh grammar lesson, we can turn to the appendices to our skeleton. I think it will serve best if I take you straight to Appendix 2, which is an extract from an English language version of modern Welsh, the comprehensive grammar. And ask you to look at the Appendix 2 to yours. Yes. Okay. Which in the page starts at 464. In the core one. And the first reflection I want to take your Lordships to is at page 466, which is under the heading Section 144, relative pronouns. And it explains.
I did have 466 in the core one. Yes, I do. In one of the statutes.
Yes, I think it'll be the
Modern Welsh.
that's the yes the title piece. The third page then is Section 144, relative pronouns. Explains what a relative pronoun is. And then there's a paragraph which says, but in Welsh, third paragraph down, there is no real equivalent to the English relative pronoun, and instead the language uses either a special relative form of the word board,
where appropriate. It is sieve, I'm shortened to C, S-Y, refers to paragraph 229, or proverbial particles to convey a relative sense. We're about proverbial particles. But if we turn over to the present relative C, 47, the verb board has in the present tense only a special relative form C or sieve. This underlying form sieve, though common in even informal writing, is the less frequent in the modern spoken language, though it will be heard in more careful speech, and in one particular sentence where it appears usually at the end of the sentence. The basic meaning of sieve in this context is which, who, is or are. It therefore corresponds to my, board, but with the additional relative element which, or who, included as part of its meaning. This relative element must be the subject of the verb. And then it gives two examples. Look at the mess which is here, and bring those letters which are on the table. So, hopefully with that in mind, the wording in 52A will make more sense. We can see then that the clause is broken, the sentence is broken up. Os ydyn sy'n cynllunio'n sefydlu ffurfynnu ysgol. What sort of ysgol? Ysgol sy'n darparu addysg. What sort of addysg? Addysg sy'n addas at anghenion personau sydd dros oedran ysgol gorfodol yn unig. Do not ask me why they've chosen to use both C and C in the sentence. But the words mean the same thing in any event. And then that brings me to the use of only. And that's on page 468, paragraph 435. Demand in speech, and an unig can mostly be used interchangeably, but their positions in the sentence are different.
Did you say 465?
Page 468, paragraph, maybe the last page but one. Paragraph only. Demand, often mond in speech, and an unig can mostly be used interchangeably. Their positions in the sentence are different. Demand precedes what it follows, while an unig generally follows. It gives two examples. Demand, look at the second one, which is an unig. Hanner Justin or Bobble an unig sydd wedi cyrraedd hyd yn hyn. Only half a dozen people have arrived so far. And then over the page at the top, it points out that this stresses the point that you wish to make. Demand cannot modify an inflected verb so as to use the inflected picture that the potential lordship referred to yesterday in the above example would theoretically require an unig. We turn back, the example given is demand governance, and I only asked. But this next sentence, which is important, this in turn is impossible in Welsh because an unig has to immediately follow what it modifies. Here, asked. And therefore, it poses the question, one would need to say, governise an unig. I only asked. Governise being a short form preterite. So the rule we say is quite clear, and there is actually little to controvert this. If we...
I understand all of that, Mr. Williams, I understood that entirely. But isn't it what you said? What proposals are affected? Proposals to school. What school? Schools that provide education. Statement of the obvious, that's what schools do. What type of education? Only 15 plus. Everything is an expression. It's a limitation of different stages of the thing that the school is doing. And if it's doing something else, then it isn't meant to be within this.
Well, if it's doing something else, it would be providing, adding something else. And therefore, an unig would have to apply to it if it were to have my learned friends thought after meaning. But provided it does provide education, which is suitable to the needs of the people over school age, well, it will be included. Because it is the suitability of the education that they are providing that is.
I do understand that you're saying it's suitability, but I suppose I can't get away from the fact that anemic would have no meaning. So even though it's in a subclause, seen others, I think a Henyon subclause, the purpose of this is to tell people what schools are called. And there are a series of descriptions. Schools providing education, a particular type of education, and meaning has got to be given some meaning. So even though it's grammatically inelegant, the Senate must have intended to be trying to narrow down what it was that was covered.
Well, I entirely accept it would be possible to render this inference without any.
Yeah.
I mean, there was proper that I should do that. But I don't accept the word any has no meaning, because it does emphasise the type of education, suitability type of education, which needs to be provided, but not necessarily exclusive. Because that is what the use of an meaning attached to that panic would provide, meaning sixth form college. So an meaning simply stresses that if the school provides education to pupils and is the suitability of that education to sixth form pupils, then it is covered.
But why do they need to stress it? The opening word is this is all about. Anyone reading this, coming to it, knows it's about sixth form. So why are they saying this is about sixth form education, and it's education suitable to people above nursery school age? Only emphasis. Did the Senate think that people wouldn't understand it?
Well, they're stressing it because, of course, on any ground there is some type of sixth form education which is covered here, but it's not just that which is provided exclusively. It is any school which provides that education, and therefore it includes sixth form in a comprehensive.
Would you accept or not accept that even if it's grammatically not pure in the way that you outline, it can only qualify in others, and the rest, it qualifies that grammatically?
Yes.
It has to qualify that grammatically, and even though it's grammatically inelegant, if the choice is between redundancy or grammatical inelegance, it's a matter for the court to try and determine which it was that the Senate was. Was it inelegant, or was it verbose?
Well, if it's redundancy, of course, then we're right about the meaning. If it's, I mean, it's not problematic. It does. It could have been rendered differently. It could have been rendered far more clearly by using one of the methods in Schedule 2 or Section 71, yes.
But if it's a question of having no purpose, the Welsh words, meaning, or being grammatically inelegant,
But, well, if one is to give proper meaning to Section 156 of the Government of Wales, with respect, it's not open, we say, to someone interpreting this, to simply say that's grammatically inelegant, therefore I'm going to assume that it applies somewhere else. Because that won't fit. I mean, we say even in English, pretty clear. There is a obvious difference between the first two versions, I'll just raise that one and the third. This has to mean the third. It might be considered inelegant, but that does not allow one to bend the grammatical rule. It is redundant in the sense that it need not have been, but it does have this, and our submission should be given some meaning. Now, what we've just said is in fact confirmed in the Welsh Government's guidance that we were taken to briefly yesterday. That's at tab 27 in the authorities bundle. And that's why you turn on page 17, section 3.8, taking care, placing only. This says take particular care not to do.
Which page is this?
Internal page 17, Lord. Tab 27.
Electronic.
7 to 9. This calls for care when using the word only or the Welsh equivalents. Makes the point that it's surely correct. In English, only normally modifies whatever comes immediately after it. It should be placed as close as possible to what it modifies. In Welsh, the phrases that include on normally modify what comes immediately after on, while an ene normally comes after the word or phrase that it modifies. That confers precisely the grammatical rule I've just taken lordships to. It says, however, ambiguity may arise because of all the expressions can modify whole phrases as well as single words, but in our case, of course, the ambiguity is solved by the breakup of the clauses, because of the C clauses. This guidance, I thought I was going to hand it in yesterday,
What do you mean by the breakup of the clauses?
The fact that whether or not there are commas, the sentence is broken up by each time the word C is used.
Explain that. We look at the language in Welsh.
Yes.
You say that a clause is denominated by the use of the word C.
Yes.
Or C. So there are two usages of those words.
Yes.
After school
Yes.
and after the sermon.
After Addis. Yes. It's true that there is a third.
Right, so there's three.
So there are technically 3 C's. Yes.
Why did we qualify cross order and Haskell then?
Well, I mean, theoretically it does, but that amounts to the same thing, because this clause is effectively addas atgenion personasi dros oedran ystod gorfodol.
Grammatically, I thought you just told us it comes after the last clause, and the last clause is cross order and Haskell gorfodol.
Yes,
That's school age.
but that would have no meaning other than the meaning that we contend for. It wouldn't make any difference.
No, it would. If it's above school age only,
Exactly.
it's the meaning you don't give. I mean, what I don't understand is how you can say that this is, I mean, I understand how you can say it's broken down into clauses, but it seems to me easier to construe anything. I mean, the thing I find most unhelpful about the judge's judgment are the square brackets in the clause, breaking it down into clauses, because actually, if there are no commas, the thing has to be read as a progression.
Yes, that was intended simply so that the precise meaning of each word could be understood.
That's helpful from that point.
It wasn't intended.
But it's not a good construction tool, because I mean, I can't read the Welsh sufficiently accurately to do it in Welsh, but just doing it in what one might call transliteration. The proposals to establish a school which provides, proposals to discontinue a school provides education suitable for over 16s only, is a progression, the which doesn't disconnect the language. So you can have as many whiches as you like, and we've got 3 of them, but they don't disconnect the language, because you're actually talking about discontinuing a school providing education for over 16s.
Yes. My Lord, the difference of the final C is probably you can take that out and it will make absolutely no difference whatsoever to the sentence.
It hasn't been taken out, so.
But it doesn't change the submission that I'm making, my Lord, that an ene applies to the, it must modify what it comes immediately after.
So what comes immediately after is cross order and Haskell gorfodol. Because of school age.
Yes.
Because of school age only. And that's helpful, because if it was people who were below because of school age,
education which is suitable to the needs of persons who are over compulsory school age, then that includes the sixth form as part of the comprehensive.
But if I've understood the Commissioner correctly, I don't think you haven't, if I haven't, what you showed the grammar is the word in ENA qualify what comes immediately before. And you say that's what comes immediately before, and it clearly marks subclause. What clearly marks subclause is C from the word board or C for factory. And the last D we have is before compulsory school age, so it can't qualify as C now that, and we're getting on. That's from 9. It qualifies what those personae are. Personae who are docile and not docile, people who are above school age, anemic only. So anemic qualifies the words.
Well, I don't.
Over long words.
Yes, I don't run away from that, but the conclusion of the mathematician is the same.
Yeah, but grammatically, if you say for ages, it's been out there for the qualified, and it isn't, it's been dropped.
I do take the last clause to run from C. It actually makes more sense because over compulsory school age is effectively being used as an adjective.
That's because you're choosing to read that clause as not a true subclause, but as a subset of the previous clause. And the Chancellor was asking if you're doing that first one bit.
It does actually read better, but I'm not trying to be inconsistent, and I take your lordship's point, but all that means is that the conclusion is the same. Does the school provide education which is suitable to people who are only over school age, i.e. sixth forms? If it does, then it's covered. It doesn't actually change anything, but I entirely accept your point. To be precisely consistent, I suspect
and
this
what you just said doesn't make your case. If it provides education for people only over school age, in your case, it's good enough.
No, but I don't say that it says that, because if it does it provide education only, would mean that it would be qualifying Darpari again. Does it provide education for people?
Let's put the question differently. Let's forget all the subclauses. Schools for which children? Children over 16. This school's got a child of 15 and a child of 14. Is that what? No, because it's not a child over 16.
Oh my God, you just know in the sixth form, I mean, what is it? There can be some children.
Oh no, but they are there. Yeah, but the point is, it's a school which does certain things, providing education suitable to certain requirements for certain people. Which people? People over compulsory school age. That's what it's getting at.
But it's providing education which is suitable for those people.
Yeah.
And if it does so, it therefore covers the situation.
Which has to be suitable for people over school age only.
Well, sixth form education is suitable for pupils over the age of 16.
Only because if they're 14 or 15, they haven't got to the stage yet where they can understand the 16. If you're 16, it might be doing 15. But if you're 15, unless you're very clever, you wouldn't be doing the 16. But if it qualifies children who are there, if this clause is trying to tell people when you must go and get approval, it's saying it's got to be a school, we're not closing supermarkets. It's got to be a school providing education that's suitable. And who has it got to be suitable for? Only people over 16.
Well, no, that is not what that final part of
You know, we're getting around in the circle, Mr. Williams, that one does with points of construction. I mean, we had your submission, and I mean, the two new points to me this week are the Welsh grant, which I may say I find very helpful, and the three clauses and the three uses of the C, which also. But I mean, I think we have your submissions, and I'm not sure they'll be improved by a repetition.
Right, that's probably a fair point. I do have, for goodness' sake, the Welsh version of these clauses, of this guidance, has the advantage that the examples given are Welsh. Disadvantages chooses to use the word demand. But
Right, we'll have that.
think one has been looking at soft copies of the word. But that's we would say that despite, I'm sorry, I was just going to say that the principle is also accepted by the Welsh Language Commission in his written submissions at paragraph 15. It is probably worth me making point in passing. The Commissioner sets out a number of submissions on the status of the Welsh language text and how it should be interpreted. 16 to 19 submissions, and we would agree with those. I suggest that is the best approach to the correct interpretation of the text. Perhaps if I can turn then to contrast with similar provisions found in the elsewhere in Part 3 of the Act. We say that the provision here is to be in contrast with the wording, first of all, of Schedule 2, paragraph 5.2. So again, if we look here at the English version, this is tab 4. This deals with regulated alterations dealing with age range, and as we set it out in our skeleton, the alteration by a year or more of the highest age of pupils within education is normally provided to the school. But the school, both before and after the alteration, provides education suitable to the requirements of pupils at compulsory school age, and then the words are added, and does not provide full-time education suitable to the requirements of pupils over compulsory school age. If this, if Section 52A were to have been intended for by the Council, then the corollary exclusions that should have been included and would have been given this. Furthermore, we've already referred to this. The Section 52A is to be contrasted with Section 71(1), which deals with the Welsh Ministers' powers of initiating intervention. And there we see. We can look at either 11A or 11C. 11C is probably the more appropriate. The Welsh Ministers may make proposals under this section for the discontinuance of one or more maintained schools to provide secondary education suitable to the requirements of sixth formers and no other secondary education. Again, a similar phrase could and we say would have been used if Section 54 in the way the Council contends for. The Council's right, of course. It means that Section 52A effectively applies to sixth form colleges, and we say that would seriously undermine the additional protection which the Act and indeed the Code gives to schools which provide sixth form education when a proposer is considering to discontinue that education. The reason for that, well, this doesn't really seem to be contested. It is that such additional protection is found in the way in which post-16 education is funded in Wales, and there is a description of that, my Lord, in the supplementary bundle. If you're to take for the reference, tab 18, page 317. Tab 18, 317. It's in the exhibit to the statement of Catherine Lyles. And probably suffices to read the overview on page 319. And certainly the first sentence, which reads, funding for further education institutions and school sixth forms are funded in different ways. It doesn't say sixth form colleges.
that was a point. So what we say is that the judge's interpretation of this section was entirely consistent with the Welsh Ministers' direct responsibility for superior education because at first school age, soon section 71, as he found in paragraph 82 of his judgment. And in closing on this ground law, just this one final solution. It's common ground that closures of sixth form colleges at least are covered by section 15. It's also clear the situation that closure of sixth form alone, where the remainder of the school continues, is covered by section 52B and section 2. If Welsh Ministers funded sixth forms are not to be protected in these circumstances, are to be protected in those circumstances, what are the logic for them not when there is enclosure of an entire school, both pre and post 16 pupils, especially when pre-16 education is to be retained by the opening up of a new school, perhaps even on the same or adjacent site, but with a slightly altered age range in view of the sixth form. It really doesn't make any sense. I'll turn now to grounds 3 and 5. You've been taken to the code, the Welsh Government School Organisation Code. In our skeleton, we refer to some of the first statements on that. It was the case of McCann. We've set out in our skeleton two passages. I'd like to refer to the second. This is paragraph 44 of the skeleton. Because our learning friends pointed out the difference between where there were mandatory rules in the guide and where there was guidelines, requirements, there was guidance for those. And in McCann, the court went on to consider circumstances in which the local authority, having regard to the guidelines, in the code when they may depart from it. It said, a person to whom the code is addressed is under a duty to have regard to the guidelines, but is not under a duty to follow them. However, unless the careful interrelationship of the instructions and guidelines and the significant role given in the code to the latter are to be undermined, it is necessary that the decision maker who departs from the guidelines in a material way should have a proper reason for doing so, state that reason. Referred to. Now, we maintain that the Council breached the provisions of the code and took this decision in the 18th and it certainly failed to give proper reasons for deriving from the guidelines. The principal is a paragraph 1.9. There's always been in place. There was an ancillary breach in paragraph 1.4.
But wondering, the case that we go through in short is this: the judge forgot to note, or didn't mention that heading, and the heading says specific factors for people that might proposals to reorganise secondary schools or to add or remove sixth form. And the proposal for is not to authorize sixth form, is to those on-site employment. That's what's put against it.
Yes, that's ground 3. Before I address that directly, I did just want to say how the claimant did put it to case. We were given the further aid to amend the extended factual grounds to include the ground that was just referred to. We say it's clear from that it was predicated on the following matters. Firstly, that the effect of the proposal on the provision of Welsh regional education in the Pontypridd area, as set out in the evidence that was filed in support of the original claim, going back to October 2019, and a particular note with a statement which detailed the likely loss of relevance to the Welsh education system as a result of the proposal. Secondly, was the proposed findings in the investigation of the Welsh Language Commissioner, which confirmed in respect of the consultation been a failure of the council to comply with the standards. We said were relevant to the education sector. And thirdly, that removes 6 forms, namely automatic sustainability and Welsh network, which we say clearly breach of 9. Now, in the detailed grounds of resistance in response, so at the same time as the first tranche of the evidence, the Council stated that its obligations under the Code, so far as the Welsh language is concerned, were found in paragraph 1.4. That's the detailed grounds of resistance, which are in the core Bible. Recommends for the authority to publish a Welsh language impact assessment where proposals affect schools in which Welsh is used in instruction. This is what the Council did, therefore there was no failure to follow this code. There's the provisional finding of the Welsh Language Commission found to report about consistent claims. The Council was not proposing any changes to Welsh medium second, but instead to Welsh medium primary. Welsh medium second provision was considered when developing proposals as part of the Council's consideration of its Welsh in Education strategic plan. Now, we found further witness evidence which referred to the likely loss of learners to the Welsh system as a result of the proposals. This was a statement of Catherine Lyons on the 4th of May. And she also responded to the detailed grounds of resistance and set out the Respondent's criticism of the Welsh language impact. See that in the supplementary at tab 18, pages 311 to 314. Important this last edition is what she says at paragraph 93, where she takes up what Council had said in its organs of resistance at paragraph 72. The Council's eventual preferred proposals did not entail a reorganisation of Welsh medium provision for those aged between 14 and 19. The Council did not consider what impact those preferred proposals would have on Welsh medium provision for those aged between 14 and 19. Because to do so would have been pointless. The proposals clearly had no relevant impact because they concern English provision. They goes on to criticise that statement. But the point is that Council's defence was provisions were not engaged at all. No, we didn't consider this, but we didn't need to. And it's in the light of that submission that one needs to look at the third ground of the law.
Is that
well, my Lord, my Lady, she did. Council did try to row back from that, but it's plainly the case.
But you say row back. She made a statement that some of this is being common sense, which is that there is recognition of changes to Welsh medium primary education requirements and take the Welsh medium secondary education.
Absolutely. That was an admission, if that's what it was, that both the claimant and the court latched on to, accepting the inevitable, that in fact, simply because the proposals didn't concern Welsh medium secondary education, did not mean that secondary education wasn't going to be implemented, and therefore that the provision in the code wasn't applicable. But what the concession was
in the detailed grounds was that it may have been their case then that it was pointless, but that they had not considered this impact.
I'm sorry, my lord, my lady, that was not our case. I'm sorry, we said we had considered the impact. But the point that we are making is that we, in respect of the English medium proposals only, that is to say, the proposals which concerns reorganisation of reforms, proposals 1, 2 and 3, the impact we considered at an earlier stage when we were deciding should we reorganise English medium education, Welsh medium secondary education, and we accepted that the Council had not gone back in respect of those proposals at the determination stage and said, and now let's look, having decided to proceed with these proposals, the purpose was only in English education, how they might affect some of the Welsh medium education.
Well, perhaps I was wrong simply to refer to this by cross-referencing the statement. But at page 109 in the full bundle, at tab 9, there is a case. In relation to what Ms. then said in her further statements, the claimant had various criticisms. There, when we look at ultimately the Welsh, I think where one would thought, but it was woefully inadequate in dealing with it at all. And those were the submissions that we made, and those are the submissions the judge accepted, as I will come to in a moment. What I want to know is to make good the case for Lisa Howell's common sense and let's say acceptance that there was a link. The Council says that the Court erred in its interpretation of paragraph 1 because it relates to 6 form proposals and is not concerned with proposals to reorganise primary school. In the grounds of a little, in the scale of 9, a little more advanced than the state. And we simply adopt the position that we set out at the trial, which is in our original skeleton, and accepted by the judge in paragraph 101. That's at tab 7, full bundle. Pages 69 to 76. And in summary, the 4 proposals were intended to reorganise, or have the effect of reorganising secondary schools and removing 6 forms. There were changes to the Welsh medium primary education in proposal 4. They inevitably impacted on the take of the Welsh medium secondary education. Any proposals therefore to change Welsh medium primary education should have considered how that might affect sustainability or enhancement of the Welsh medium secondary provision in the 2019 network and access to post-16 Welsh medium courses. Now, it is undoubtedly the position that the Council's proposals were intended to provide a large-scale reorganisation of education in the area. The interconnected proposal included the reorganisation of secondary and the removal of 6 forms, together with the changes to Welsh medium primary education. The Council accepted, and I think still accepts, that the proposals are interconnected. There's a little bit further. And there were various references in the bundle before the Court of Justice. But the Council's skeleton argument does seem to accept that, even now, at paragraphs 1 and 53. That's the core bundle, paragraph 23. Pages 282, that's point 1, talks about the decision to proceed with 4 interconnected proposals comprising a large-scale reorganisation of schools in the greater Pontypridd area. And then 2
in the footnote actually, at the end of paragraph 53, under the thought of its interconnected proposal. That is precisely what the judge found. 3 paragraphs in his judgment, 789 and 50, and 150. So again, it's tab 7 for bundle. Page 46. Where he said at the beginning of paragraph 7, the proposals are all interlinked. At 89, page 66. The parties each explained, although in different terms to one another, the proposals were all interlinked. Paragraph 150 on page 80. So, in this submission, there really can be no dispute. They are legally all separate proposals. As a matter of section 48. Each one is separately. Each one has subject to a separate notice, yeah. And separately, if you apply to one and not the other, they're interlinked in the sense that it's coming out of the whole Pontypridd. So in your case, it's got to be in the heading 1.9 essentially. When you take a proposal to reorganise the or to add or remove that form, all proposals connected on each of those. Page 29 of 3, that's the case again. So you're also referring to the heading in the code. It didn't fact that yes, it was revoked when the proposal to reorganise the was rather or removed. Proposal 4 would not of itself fall within that. Not proposal 4, but proposals 1, 2, and 3. Yes, we're not containing it. But what we say is all 4 proposals were interlinked. For instance, in relation to 2 and 3, they involve not only proposal in school and the reciting of the new units, the reciting of one was referred to the new Welsh Ministers. As if we on search if you take proposal 4 and we forgot for a moment would proposal 4 fall into 1.9 or would it not? As it is. Proposal 4 had been advanced on its own. There had been no other proposal. So it's because it's linked to proposal 1, 2, 3. Yes. But as it was linked, hold on to it. Was linked to proposal 1 to 3. Before the limit. Yes. It is clearly executed with not simply proceeded with so it's if there had been no other proposal than proposal 4, as it was paragraph 1.9, all of them based on to be applicable. There were proposals to the other that would have been, of course, no less that there would have been an effect on Welsh media. One then would have been looking more closely at paragraph 4, which of course is in all cases, and the third paragraph is the second bullet point, which reads, in all cases, because of the schoolwork provisions being reduced to remote must be able to continue receiving education that provides at least equivalent standards and opportunities for progression in the current media. Specific transitionary events may be necessary to achieve. But given that that wasn't the case, the verb is which we say paragraph 1.9 wasn't. Therefore, that was the gravamen.
I'm sorry. This wasn't the case that was run against us at trial, and I do have a fundamental difficulty with a case that would demand new actual investigation. And this is the necessary links between proposal 4 and proposals 1, 2 and 3, and whether one can continue without the other, now being advanced on appeal. At trial, this was put forward squarely as a breach of paragraph 1.9 by reference to proposal 4. See my learned friend's statement.
No, that's precisely what I've just said. Although I didn't take notice to the provisions in our skeleton, simply summarise them, that was the case that we put. There were 4 incidents and paragraph 1.9 was involved, and the council did, because of the obvious knock-on effect of the organisation of the primary schools, did need to consider the reporting to 1982.
Which was very disappointing, and that proposal to be quite got the facts from. The English medium people that here at LA will go to the new author, and the Welsh medium ones will go to the new on-side one. But you point forward.
Well, I believe there's somebody called Sean Martin.
It's not starting with that, it doesn't matter. It's got that wrong then. The point is that the English language right will go from new curriculum to the curriculum, so it's a good going school, and open new Welsh language school where you go to English.
This is presumably why the council agreed we were.
That's your point on that.
Yes. Now we say it was uncontroversial that the attention of children in the Welsh medium secondary education was dependent on the availability of Welsh medium primary education. And therefore, of course, the continuation of the transition from school to it was never formally considered, but the council did accept within some witness evidence, seconded the changes to Welsh medium primary education can have an impact on the secondary. The judge 14. So the respondent's case then was that proposals involving the changes to primary education should consider the changes to affect sustainability. The court accepted that logic at paragraph 115. That's bundle, that's tabs, 4 bundles, tab 7, page 72. Accepted the submission, and we say he was right to do so. And also, I've just been reminded of the paragraph which is skeleton which says the witness points to 4 bundles which was traditional. So that's the thing down to what we were saying. 21. Our case on this, the knock-on effect was supported by statements from several witnesses who gave evidence as the likely loss of children from the Welsh education system should the proposal succeed. And the judge summed those up as saying that pupils not from Welsh medium education are lost forever. In the evidence in the judgment of paragraph 114. Our case was also further supported by an email from the Welsh Government on the 23rd of January, which highlighted the absence of information regarding the extent to which the proposals supplementary handle between page 278. So, in the light of the Council's approach to its obligations under the Code,
case was that the consultation document was lacking. And the Respondent made several points of evidence in respect of the appellant's balance sheet analysis that was found in the Welsh. They also looked at the community impact assessment and quality impact. So those are the arguments that I originally started in 13. We maintained throughout the Council has failed to assess the impact of the proposal in any meaningful way. And those are the solutions that paragraph 119 of this judgment. That's at page 73 of the order. Described it, the Council also relies on the Welsh Ministers as well as the community and quality, but then in support of the assertion that considered how to build the Welsh Minister education. The Welsh Ministers, even though it was updated, extraordinarily in terms of the impact on the Welsh proposal. It goes on to say, further down, nor does the Welsh Land Impact Assessment strike one as considering the sustainability of or enhancement of the Welsh media provision, stated in the code. The assessment contains a large amount of broad assertion, amount of it concentrated on transport issues. I would estimate that in absolute terms only about 10% of most of this document even considers the impact on the use of the Welsh Land before, let alone the sustainability of the Welsh media education document. Cites commitment to the Welsh Government's Cymraeg 2050 target. But the law is required of the code, and it's a simple recitation. It's critical that the impact assessment fails to assess the functioning more preventive looking for project-for or municipal communities and moving forward. It also fails to consider the point I've already mentioned, how the changes to Welsh medium primary education will or may affect Welsh medium secondary education. My judgment, the inadequate point of the Welsh language impact demonstrates there is nothing either in the quality impact assessment or community to make this efficient. Now, the Council continues to maintain that paragraph is much engaged because its proposals to meet the reorganisation of Welsh medium between 2014 and 2019. And we simply say that assertion is wrong for the reasons that we've given. And the acceptance that they failed to comply didn't sits very awkwardly with the assertion now that, they actually did it from the judge analysed it in great depth and came, we say, to the right conclusion on the evidence. It won't possibly say that there was compliance with given, despite the full assertion.
Can you explain why that is? Because as I understand it, you're telling me if I've misunderstood it. What is said is that there are three ways in which this could affect people using Welsh primary schools in the future. One is to think about council guarantees. The second is, would there be enough places to protect us? And they say we've got 93 extra places. The third would be would deter from going on from too far away. We might offer an easier right or community, and those people often. And what Mr. Milford says, if you look at the information in the documents, that's why there was the emphasis on transport. They considered and taken the view that there will be no loss. So if they've done that, is there anything else about the impact on the Welsh medium secondary education and store work that has been taken into account?
There was specific evidence that there would be lost learners, principally for the third, the additional transport, and that all follows on having to take transport to school, which would be school.
Yeah. Well, they say nearest documents because that but the judge wasn't really impressed by the evidence individually. He didn't think I got it. Yes. So what's your response to the fact that there were 3 ways in which, in reality, punitive requirements were level and affects equity, and each of those has been addressed AC?
The judge's conclusion was that the mere assertion was not sufficient. I mean, there wasn't any analysis that what the effect would be of the proposals on Welsh medium education in the 40 to 19 years. But that of course is well advanced into secondary school. We've got 11, 13. But there was evidence, and he said that the general principle would be pupils lost, and there was simply no detailed analysis of what would happen. Simply to say there will be school transfer. My submission was not looking for found. Simply to say, well, there will be enough space again. Spaces is given many options. And this was a cross-language commission in relation to education. How the parents regarded the local school as important. Just and my sense there was ample evidence to come to those conclusions, and perhaps that the council had come late to the table, perhaps it better addressed it, and was searching anywhere. Certainly we say there was nothing wrong or illogical in the findings that the judge made in those respects. Turn now to ground 4, which is the judge is going to find the balance of which in accordance with the position proposed. I've said that what the principal case of the respondent was. The appellant now says that we didn't allege there was a breach, that the defendants had no opportunity to address this question, and that the findings were manifested. We say each of those without foundation. As we've already seen, it was in the detailed grounds of response that the court specifically cited as being effectively its only duty in relation to the Welsh. That's what it was. And it said that it complied by meaning choosing the Welsh language impact. We responded to the reliance on the Welsh impact in the context of the assertion there had been a breach of paragraph 9. But said it was so vocally inadequate. Hence the evidence was filed by Catherine Lyons to the effect. There was evidence files referred from police Howard, which purported to explain the decision and how to comply with its Welsh language duties. But it's, in the light of all that, really not right to say that the council did not the proper opportunity of addressing the issue of the breach. But some time was spent dealing with the issue. Though I accept always in not principle claim. We say that the court was therefore within its right to make findings on the sufficiency of the interpretation of document, but also the Welsh language impact assessment, for the purpose of establishing that there was a breach of Paragraph 1.9. And having made those findings, what further to make a further extension, but the was also reached 1.4 in the same fact. In any event, the formal finding of breach in effect takes the improvement which if there is any suspicion of visual irregularity, this matter ought to be raised with the judge. Round 5 then is that the court over finding that the appellant failed to consider how its proposal to Welsh Ministers education would impact on the enforcement of second legislation. To a large extent, the leadership has already dealt with. Of course, this is the case that it would not normally be the case that evidence of this kind of assets would be subject to cross-examination. But that does not mean, even if she wasn't, that the court was obliged to accept the evidence in the witness statement as if it was unopposed. It was, with a lot of nothing allowed criticism for evidence quite approaching.
And obviously, the basis of judicial review, if you're not going to the witness from the public body of the statement of proof says considered, that they meet the basis of the arrangement. And that's the Danish document, the definition of case, or the application of cross-examination.
Yes, the contemporaneous documents did not support.
That's what you say. So the contemporaneous documents show that you would likely mistakenly believe that you considered it adequate.
Yes, it's been, of course, being produced at the time to try and reach this case. We say that the function of the court in Special Friend 2G was to review whether by reference to the relevant document, other documentation, to see whether the defendants have failed to take into and the council seems to be submitting now, or what to have accepted Ms. Howell's born as Sirol. Firstly, this was logical for the court to suggest that its defence that it decided not to reorganise Welsh Meeting's secondary education showed that it did not recognise the link between the proposal for. But the judge gave a clear and logical rationale in the judgment of 116. He says, there are two, this is the third line, page 73. There are two differences with this line of defence for the council. Firstly, it wholly ignored the reasonable thing, one which is essentially accepted by Mr. Albertus, between proposal 4 and the impact that will have on Welsh Meeting's secondary education. Secondly, it demonstrates that whenever, or whatever Ms. Howell states in the evidence now about the acceptance of the Welsh Meeting primary education and Welsh Meeting secondary education, it was not something the council realised or acted in accordance with at the time. The council decided that there was to be no reorganisation of Welsh Meeting secondary education, and so that was the end of any consideration about impact of any proposals upon Welsh Meeting secondary education. Those involved failed to address how the reorganisation of Welsh Meeting secondary would impact failed in my judgment to consider the decisions that they were making either contributed to strategic aims of increasing the use of Welsh and of reducing the use of English. I would go further and say that we failed entirely to consider how reorganisation would impact secondary education. Secondly, the council is critical of the court observations in relation to the consultation. We maintain that there was no consideration within that of the impact of sustainability. And the absence of such consideration within that notion, the absence in any other document, presented a logical basis not a consider. And well, much can be said for what the council says the court was wrong in relation to the Welsh language feedback. But again, in the absence of recommendation, that presents a logical basis to reject the motion in full resolution. And therefore, that's the decision. So those are my submissions in relation to the grounds. I think perhaps I should say something about the issues raised about Welsh Ministers. I'll be very brief on this. We saw sense we made an application. It was made as soon as it was reasonably obvious that reference to the Welsh version of the legislation was going to be made. It wasn't just for the year. But anyway, it was rejected and we understood. In the service, the trial judge, it is the best. And in fact, whatever we consider about the outcome, just a paradigm example of how it should the Welsh legislation with the assistance of the party. That is why the literal translation but it wasn't to in any way convey that the English but it was to show the syntax of the Welsh sentence so that we begin to understand the submission to the claimant. It has to be said that if this court could give any guidance on how future courts should deal with this listing of the first instance, that would be very helpful. These matters arise rarely. First of all, the discrepancy in the legislation or what is legislation or possibly contestable stuff. In my knowledge, this issue is only arisen twice ever. It often needs to be pertinent, of course, in the case in question, and what needs to be keeping means that the lawyers need to be and therefore, yes, it would be helpful in seeking directions. But it would be wrong simply to say in all cases. And we certainly do support what was said by the Welsh Constitution. I think the Welsh Ministers too in relation to whether the cannot involve in it is a matter of publication. May I just check? Those are submissions.
Thank you very much. This form Mr. James did, Mr. James Skate made his submissions in Welsh.
I shall consider myself warned. And I hope to be less.
Yes. I thought you could just help me turn this on.
Firstly, I would like to deal with matters arising in terms of principle and framework on basis and grounds of grant 1 and 2. The Welsh Language Commissioner does not contest any particular meaning, so is neutral in terms of the interpretation of section 50 of the Act. But as the other parties have stated, this case is considered to be important and appropriate for providing guidance on to lower courts as to how to deal with the statute bilingually. Following that, briefly we'll deal with matters arising in relation to grounds 4 and 5, and mainly 5, and that is the code within the context of the Council's duties in relation to consulting on the Welsh language more broadly. Even though it is a narrow question that arises on the basis of grounds 1 and 2, as in to what purpose are the words any only included in section 50, the matters of principle are very important and broad. And because of that, the Welsh Language Commissioner has intervened on grounds 1 and 2, even though he did not do so before the High Court. Because there is a body of law devolved, which comes before the courts and tribunals of Wales and the courts of England and Wales, it is not a specific element before the Court of Appeal. That's not the subject of the text. It's not about understanding the Welsh alone that's important, but understanding it in order to be able to understand the meaning of the Act in its entirety, i.e. both Welsh and English. And so therefore, the Welsh text should not be seen as a marginal issue or an exercise in ticking a box, but it is an integral part of the interpretation of the meaning. On that note, section 156, the Government of Wales Act, states that the Welsh and English texts, and in that particular act is only in English, that they are of equal standing. The same term of equal standing is included in the Welsh Language Wales Measure 2011, and the usage of Welsh is given as a status of Welsh of equal standing, so both languages are treated on the basis of equality or on a practical level, that they are provided with equality and equally. In terms of any assistance provided by this court, I note that Part 5 of the Legislation Wales Act 2019, in terms which may be a little different, i.e. the Welsh text and English text have equal status for all purposes. That is stated there. In my recommendation, there is no relevant difference between those two provisions. And so any assistance provided by the Court of Appeal in this case will be applicable for legislation dealt with by the Government of Wales Act and the legislation measure. It's worth noting that the language of the text is what is important and not the language used before the court. And even though there is a relationship between those two things, both are different. The Welsh Language Commissioner is grateful that permission was granted by the Court of Appeal when it was sitting in London for the submissions to be made through the medium of Welsh, because there was a need for permission at that time. But in any case, the Court of Appeal would have to look at the Welsh text, even if neither party made any recommendations and submissions to the medium of Welsh. And of course, without the intervention of Welsh Ministers and the intervention of the Welsh Language Commissioner, the arguments before the court would have been solely in English in the High Court and indeed before the Court of Appeal.
Mr. James, whether you say that in every case where the meaning for a statute that is in both English and is in issue, it's necessary to consider both versions? Or would it be open to the court at any stage to there was no suggestion by either party that anything was added by looking at the other version, or just look at the Welsh version, or just look at the English version, since they are of equal status.
One can adopt one text to facilitate the process before the court. But in doing so, a higher status should not be afforded to the text which is being used. At a practical level, therefore, if there is no difference between the two texts, as the court, in hearing the submission solely in English or in Welsh, usually it would deal with the legal text in one language. Practically, that makes sense. But that should not be taken to mean this is an acceptance, the solution lies solely, or that the meaning of the legislation comes solely from that particular alone.
I'm getting is that if the court looks at one language because the argument is taking place in one language, neither party before the court suggests that the other language has any different meaning, then presumably it is safe for the court itself not to look at the other language in construction.
But if there is no submission for the court which deals with the other text, then it's very difficult for the court to deal with that text in whichever language. The argument, of course, is because the meaning of the legislation is to be taken from both languages, and the function of the court is to interpret the meaning of the legislation, not narrower in the meaning of the legislation in the language before the court. There is a possibility that there is a need. At a practical level, the question before the court is the question of interpretation. And by necessity, therefore, if the court is not willing to deal with the English text in the way as the Welsh text is intended to be dealt with, then by necessity the two texts are not being dealt with equally, and therefore that's the prism in my submission through which the different methods of reaching the meaning the legislation should be reached. The stance of the parties before my lords is the same narrow point that I want to deal with is the stance of Welsh Ministers, who are limited in the situation before the High Court and not before the Appeal. Quite simply, the Commissioner notes that the argument about the ability to understand the law through the medium of Welsh before the Court of Appeal in my submission is stronger. As a court, higher recording court, it's more important that the text bilingually should be understood and understood fully before the Court of Appeal than before the case below. Although there is a possibility also that there are matters for the Senedd or the Westminster government to consider, the Westminster Parliament to consider, or the Civil Procedure Rules Committee, it is a matter of the rules and changes to facilitate any support or assistance that the Court of Appeal selects to provide in this case is what is needed, not changes to enable the function of interpretation to take place. The important principles included in my submissions are accepted by the claimant. briefly in my submission, that's the framework that should be used. And the most difficult point is the point that arises that the principles of statutory interpretation apply to the consideration of the Welsh text. English text should be used in the Welsh text. That's the narrow point that creates or can create problems, or practical problems. There is a possibility of using other methods, such as translation or expert evidence, but in my submission, they should not be considered as a positive step, but rather as actions which try to mitigate against shortcomings which by necessity arise without there being watchmaking or judgment. The Law Commissioners looked into these options, and Welsh Ministers and the Welsh Language Commissioner have made use of and have provided a copy of the Law Commission report, and on that report, for the most part, that's what my written submission is based on for the most part. I'll deal briefly with some of those matters. Firstly, the question of using simultaneous interpretation. In a case, as now, where a party wishes to use the Welsh language and the court is not able to speak Welsh, then using interpreters enables the court to understand what is being said. Simultaneous interpretation is what it is. Translation, it's a different role to a legislative translator, and a very different role for providing expert evidence. So those questions arise mostly before the immigration tribunal, where there is a need for clear differentiation between the role of experts and the role of interpreters. And that is something which has been determined, and is something which is very important in my submission. Certainly in terms of the interpretation of the legislation, but also in terms of translating documents in the place of the court. It's very different to translating documents, and that translation being agreed between the parties and included in the minutes. There's a need to differentiate between the role of the interpreter and any role in evidence or communicating legislative information. Those options of expert evidence or translation interpretation are matters that are necessary in my submission, and that they mean that the function of interpretation for the court will
yesterday today is slightly different, because we made Mr. Williams take us through ad nauseam the Welsh. So there wasn't a translation, we didn't have an agreed text, we didn't, as it happened, use the interpreter. Was there anything undesirable about Mr. Williams taking the three of us through the Welsh? We didn't even look at the English of them when we went through the Welsh.
Ond y syniad bod angen barn dros sy'n medru Gymraeg. Gellir ein Gymru i feddwl hyn. Yn gyntaf, bod angen barn dros sydd yn gyfforddus i bod yn ddeall ystyr y geiriau statudol sydd gerig o'n yn yr
yn ail, bod e'n deallgwyr athrawon unrhyw effaith.
Tax and the meaning of the legislation. And thirdly, that they are able to reach to the interpretation independently in Welsh or in English. And then finally, without commitment, without prejudice, to the language of the submissions, then the Welsh text and the English text should be treated equally. So as a result of that, in order to deal with the interpretation of legislative text, it is not necessary to have a judge that can speak Welsh and is able to hold a case, a formal case, but rather the ability to use and interpret the text before them. Now in this case, it's a fairly narrow text. In other cases, it is possible that you might need a much fuller understanding bilingually of the legislative text. Now, of course, ideally, a fluent Welsh-speaking judge would be required, but in terms of undertaking the function of interpreting, then those four criteria allows the court to fulfill its role sufficiently and adequately.
Great. Judge, competent to deal with Welsh language interpretation because it's necessary in the context of that point.
My lord, yes. By necessity, of course, that reflects the fact that there is an independent meaning to the Welsh language, and both languages are on an equal footing. But that form of wording does reflect what the Welsh language believes is required as a minimum in order to treat the two legislative texts on the same footing. The problem and the concern associated with other methods in my submissions is that the role of interpreting is placed in the hands of someone else.
You use the word, you need to judge comfortably rather than competent. Just the word.
Lady, I think both words are used. Because a judge has to be competent in order to understand the words and to reach the meaning of the words independently. Being comfortable is something that goes further than the linguistic question in terms of the judicial role of interpreting. It's possible that a judge understands the words but is not comfortable to deal with submissions around the words that is being made. Now they are two very similar words, but there is a narrow difference between them, which is an important difference. Now, in my submissions, you don't need to overcome any test before that requirement comes up. Of course, it has to be relevant, and if there are no submissions will be made in terms of the Welsh and English text, then the point doesn't arise. But this is not a question of ensuring that the court is tied to understanding the Welsh. That is not what's required. And it is a minor point to make, even though the administrative court is at the forefront in a number of ways, sitting in Cardiff and transferring cases to Cardiff that deals with public law in Wales, and that the Court of Appeal sits in Cardiff and the Supreme Court have sat in Cardiff. Sitting in Wales and having Welsh judges is different and answers a different question and different problem to the need of having judges that understand the legislation. Now, before I move on to the code, dealing very briefly with a question about the Pepper and Hart devolved legislation, I think the only point that the Commission would like to make is this. In my submissions, one must be very careful that looking at pre-legislative text in one language doesn't lead to a higher status to that legislative text. And that follows by the nature of law because of section 156 of the Government of Wales Act and section 5 of Welsh law. But as a practical issue, because legislation is drafted jointly, the fact that matters in the pre-legislative documents come up only in English or only in Welsh doesn't mean that in that text of the legislation that case is dealt with. The text is drafted jointly in parallel, so practically a single language text shouldn't be used to affect the language of that legislation. And then turning to the ground 5, of course, this is
seems what you're saying, that if you have an affair, you would need 3 judges in one meeting in such a case, because obviously you have 3 judges, each must form their own independent view of the meaning of the statute. Another judge sitting in the same court is not obliged to say they agree with one. So, I mean, you're really making realistic. There should be a full bench in statute that speaks.
My Lord, I think my submission in terms of being idealistic is the answer is yes. But I think in reality I accept that the court in its entirety should understand the language. That is what's required. And having one judge would be sufficient. And practically, of course, that was what the High Court has done when they sit as a department with one judge being able to speak Welsh and another not.
But there could A be an appeal to the court, or B, questions of legislative competence can be referred directly to the court without even going near them. So it is 5, 7, if it was an episode in Scottish space, the word coming to intervene, you'll be asking for 5, 7, so to speak, on your ideal submission.
I think at the core of it, the court itself needs to understand the text, and I fully accept that the interpretation of one judge is not the same as the interpretation of the court, necessarily. But at least one judge should be able to reach and get at the meaning and interpretation of the text in Welsh without
judges who speak Welsh, and he doesn't say, no, it isn't the I agree with Mr. Wiggins, I agree with Mr. Wiggins. Still got the problem is the judges, the court is just the word to describe who the three people or five or seven.
Yes, I accept that. But of course, the problem is a familiar one because the courts of appeal don't always agree. And the fact that that doesn't cause a problem in English doesn't necessarily mean that it will lead to a problem in Welsh. I accept, of course, that there is a question mark around how practically a court should deal with that situation where you have one Welsh-speaking judge reaches one interpretation and the non-Welsh-speaking judge comes to another interpretation. But I think the point of principle that's important is that the court has the ability to interpret the legislation and that judicial discussion is a judicial discussion.
So, Mr. James, the important thing is what you've just said, namely that the judge has the ability to interpret the legislation in language terms. What troubles me about this is that we see in many situations where court texts in French and English and judges from places where they do not speak fluent interpret. And they interpret them with a variety of processes. Of course, the judges are experts in the process of interpretation and linguistic analysis. And if I may just take an example, in this case, I listened very carefully to the submission yesterday about the Welsh text in section 50. And I take your point about a situation where there was a broader dispute. Who is initiated, or the whole of the three legislative texts is initiated and looked at and worked. But in this case, we're looking at a very narrow text, and I felt quite able to undertake a process of statutory interpretation as a trained lawyer in a foreign language foreign to me. I quite understand that to do that, that he has submission. There is done had submissions about the use of words in that language. This morning, I was interested. What I'm asking is whether you're really saying the process is invalid if you're not comfortable in the which is fine to you as a judge. And if your expertise in that, because once I can see that that is possible in an extreme case, no doubt an expert judge who has the expertise would recognize. And my feeling that you is that there are cases where the statute is being interpreted and is alleged to say different things in two languages, where a judge who doesn't speak maybe speaks certain language to a moderate level, but not is perfectly. And it just seems to me that the figures are finally that there will be many cases where it is interpreted legislation in the language following the whilst accepting that there may be cases where it is difficult to do so.
My Lord, it's a very fine margin, but it is an important one. And I think what that boundary states is this. On one hand, the judicial ability to understand the language and understand the text with the support or submissions, of course, that is, submissions to persuade you as a court. But on the other hand, a situation where the interpretation is received from the submissions that are made. And in the second case, the Welsh meaning doesn't come independently from the Welsh words, but rather come from the submissions that are being made. And because the two languages are on an equal footing, therefore the words themselves need to be understood. And therefore, and then it is a case of persuading through submissions rather than the submissions themselves creating a basis of understanding or interpretation or understanding.
Our company with you at the moment, speaking only for myself, is that in this case we see as an example the word in Welsh education is the word in Welsh education. Nobody is making a submission that it doesn't mean exactly education. And so you have to identify what you're arguing before you can decide whether the process of interpretation can be conducted by somebody who is not comfortable in Welsh. It cannot be a binary submission. In one case, take a case outside this particular language, there might be an issue as to whether a particular word in Welsh had the same meaning as a particular word used in the English statute. And you would have to have submissions maybe from the evidence, from linguists, historical writers, look at that word in its context, where it is used. When we look at the dictionaries, we see that dictionaries refer to the usage of words in historical documents, and that informs the process. Now, that can be done without being comfortable in the entire language if it's simply the meaning of one word. Conversely, if well, I find it quite difficult to see the situation, but there could be where the thrust or the expression would only be applicable to a fluent speaker of that language. Understand that. What I'm asking whether you accept is that there will be many cases are far less binary. History is intelligible to a non-fluent speaker and perfectly properly instructed by a person who has heard submissions on all the relevant factors that go to the process.
Lord, I think the only way to ensure that the text in both languages are treated equally, if the method can be used in both languages. So, a corresponding situation is a judge that can speak Welsh and advocates that make submissions through the medium of Welsh, dealing with a statutory test at a text in the medium of Welsh, and that they are using a dictionary to reach the meaning of the word in Welsh, rather than the court looking at the statutory English text. And in my submissions, that is not a situation that the court would allow with the English text. So therefore, by necessity, it would not be a situation that would place, or would hold the Welsh on an equal footing to the English. My Lord, I agree that there are different extents of the need to understand, and in response to Justice Lewis, I used the 4 criteria that I did, but an integral part of those points is that the Welsh itself is understood, and not the meaning of the Welsh understood in any other way, such as expert evidence or a dictionary.
If I am told that the word education in Welsh means education, then you do understand.
My Lord, I must agree that it would be possible for a non-Welsh speaking judge to understand Welsh words, but the question of interpreting legislation in Welsh is different.
Sometimes it is, and sometimes it isn't, which is why I'm trying to get to the bottom of your submission. In some cases, the interpretation of legislation is simply to interpret a word. In other cases, it's to interpret syntax. Here, as we know. But there are a whole variety of exercises in interpretation. And all I'm really putting to you is that it depends on what type of statutory interpretation is an issue, whether it can be done competently by a non-fluent speaker. I mean, we have seen here that Lord Justice Lewis has an understanding of Welsh. He is able to speak somewhat. He doesn't be openly fluent.
You know, in literature, I go through Welsh.
But he does speak some because he's done so in court. And the point is that what I'm trying to get to with these James is whether you accept that this question is not a binary one, and that there is a scale depending on the history before the court of what is required fairly to interpret the Welsh. I think everybody accepts your primary point, which is that both texts equal status must be accorded equality and have to be looked at where there is a dispute that they don't need to say. So, not quibbling with it, but even accepting what I'm putting to you is that there must be a gradation in what you need fairly, justly, and properly to construe a statute written in 2 languages.
And my Lord, in my submissions, I think the form of words that whether a judge is comfortable and a judge who is able to understand the statutory text before them would allow for that wide scope of cases. Not so a judge who can hold a whole case through the medium of Welsh, or who is on a formal list of Welsh-speaking judges, but someone who is comfortable. And in that case, of course, if it's just one word, which is education, this, if that is the disagreement between the parties, then I'll deal very briefly with ground 5. Now, the submissions of the Welsh Language Commissioner means that the factual decisions of the High Court were correct. You were taken yesterday to page 221 in response to questions yesterday and this morning to Lord Justice Lewis, the numbers and transport were discussed, and what the final paragraph on page 221 says is that rather than just 70% of those in Ysgol Gyffredin Cymraeg on Sean Norton that used school transport at the time, that would increase to 100%. So by necessity, therefore, 100% of those pupils would live over 1.5 miles away from school. And please correct me if I'm wrong, but there's no evidence at all before the court that the council, as I understand it, will provide transport for school hours and extracurricular hours. And what that paragraph says in the final sentence, it's common for learners accessing Welsh medium education to be transported to and from school, and access to before and after school activities can be a challenge in these cases. By necessity, therefore, as a result of the changes in the Ysgol Gymraeg Pontypridd Norton, that rather than 70% using school transport, finding it difficult then to participate in extracurricular activities, then in fact the whole school would have to use school transport, and therefore would come across the same problems. So it's these questions that the Commissioner emphasises. Not only choosing a new, larger school with more surplus places, but changes that affect the daily issues that people want to receive Welsh medium education or not.
Do we have a solution? I see what you say about it's 100%, and there are 30% who might be deterred. And because we don't have a policy on school transport for after school activities, but in fairness, Mr. Minister took us to page 212, and the penultimate paragraph, and we may say, not enough, last paragraph, the last sentence, the English sentence, it is not considered that this school will be a barrier to any charge in which taking the pre and after provision, and whether they're going to provide school education or not, they're the elected council, well, we're just judges, and they are saying in this document, we considered it, and we think it will be all right. And unless it's irrational in public terms, we can't decide what, going up and down on the valley and changing the public bus station. And that's enough.
Except that the factual matter that I wanted to highlight was under 221, page 221 says, is that there will be more problems, more difficult, rather than being easier, as the council suggested yesterday. Now, the question of accessibility and availability and of Welsh medium education is something that we need to consider by looking at a number of different elements. But choosing a site was one particular issue that was raised before the High Court, and that was accepted by the High Court. But again, emphasising the fact that this is not a mathematical exercise. This is not a case of comparing numbers, but rather looking at the impact. And at the basis of all that, the Welsh Language Commissioner's submission is that only one consultation document was published for all the changes, and that is the grounds of the report and outcome of the decision of the Commissioner on that one consultation document, which is applicable to all the changes before the Commission.
This is not a challenge based on an alleged failure to consult. This is a different challenge that the decision to implement under a different section, 53 I think, whatever it was, failed to have regard to the impact on Welsh secondary education of closing on Rhondda. So how does the consultation document, which isn't before this court, affect the question of looking at the things that might impact on Welsh secondary education? Has the elected council considered them or not?
Well, as I understand the case of the claimant, because, and they are different, but because the standards have been breached, it therefore means that the necessary information is not before the council to reach a decision. Now, of course, I accept that that is not a matter for the Commissioner to see if there's a breach of public law, rather than any duties around wider consultation in this case. That deals with the relevant question of evidence.
We've got statements, we've got the community assessment, we've got the Welsh language assessment, we've got those other strategy documents, and we're looking at different, and you're looking at consultation, where the people of Rhondda Cynon Taf properly informed. That isn't what they're complaining about. They don't say they weren't properly informed. They say when you took the kind of decision, you didn't think about the consequences. So it's a link between the two.
I fully accept that. Because there's, without having a consultation process that deals with the Welsh language as it should, and therefore does what is required by the Welsh language standards, that means that something special is needed to show that the consultation process has dealt with these issues. To put it simply, if they don't get it on the consultation document, then where does the information that undermines the consultation, where does it come from? Lord, that is what I have to say about the code on ground 5. You have my submissions around the principle and the use of the Welsh language. So unless you have any further questions.
You're being supplied with a veritable array.
Well, perhaps I can start before looking at pages. Four brief points on the claimant submissions first, and then one point that my Lord Justice Lewis raised with me yesterday, just the first is my learned friend's point on offending, in answer to the issue, why is the phrase meaning there at all? And you were taken to section 21.2 offending, passage about deliberate tautology or words that are necessary rather than things, by reference to what Lord Hoffman in all the central claims, that being, it's not unusual for Parliament to say expressly what the courts would have inferred anyway. And I just make the brief point that this isn't a case of the Welsh Assembly saying expressly what the courts would have inferred anyway. And on the claimant's case, it's the opposite. It's the case of the Assembly saying expressly precisely what my learned friend says the court should not know. And in that case, there are obvious reasons we suggest why an argument against redundancy should carry very considerable weight. You can't stop with the phrase meaning and say, let's disregard it for the tautologist if it changes the meaning. The second point is what is said against me on purpose by reference to section 71 of the Act and the Welsh Ministers' funding. And this picks up on the point that Lord Justice Lewis raised yesterday. Said well, there may be a reason why section 71 is narrower than section 50, because under section 71 it's logical that the Welsh Ministers can only make proposals concerning sixth form education for the fact that their funding responsibility, but it proposes to get rid of sixth form as part of wider proposals, and the Welsh Ministers weren't able to stop that. Their functions in respect of sixth form education could be undermined. I understood that that was the suggestion being put against me on purpose. My response is that first of all, we say there's no evidence that that sort of subtle distinction of purpose from the pre-legislative material. There's nothing in the text to suggest that the court has given a distinction from the ambit of the two sections for this reason. But more, we say it's not a real policy. The Welsh Government have all the power to intervene without any policy given section 50 or wider in section 71, because if a local authority proposes a school including it's always it's to say you local authority should create a system, or you should add a system to an existing school. We think there should be a system in this area. Here is our proposal under section 71. And indeed, if what the local authority were to do was to close schools with a system, reopen a new school without a system, it would always be open to the Welsh Government to say under section 71 as a system. We think there should be. So we say there's no policy gap, and you don't need to have the blunderbuss of being able to stop completely for the whole school, which happens to us when you've got the ratio of being able to add the proposal with only under section 71. My third response this morning concerns ground 3. In my submission, my learned friend has not adequately explained why 1.9 of the code is engaged in proposal 4 at all. He accepts that if proposal 4 be own, it would not. But he says that because it's linked to proposals 1 to 3, it does. And my response to that is not what the code says. The code addresses proposals. Each proposal here, and Lord Justice Lewis indicates, it is legally separate. It's published by a separate statutory notice, albeit that we are, as we will accept, part of the wider school reorganisation. And my learned friend does not explain why the code should be read differently just because more than one proposal comes forward at the same time. That's what we say on ground 3, and quite apart from your answer on the facts on ground 5.
Two minor questions about that. When you say that's enforced by the fact that 3 of the proposals are going ahead, even though Carbon and Newman touched off the Welsh Ministers anyway. But what you say to me, sir, is quite that you can't have proposal 4 unless you have proposal 3, because you've got to put the English here academy children somewhere. Well, it's English speaking, but they're Welsh like, well, they've got to go somewhere else. And they're going to 4 at the moment. If you don't do 4, where are they going?
Well, I think the answer is it's not. But the answer is you might have a slightly different format, and you'd have to decide in a slightly different way where they should go. So in that
I see, so you would have closed it. You would put the English medium children somewhere else, under 3, and if you have to off proposal 4 because something's happened to it, then you're stuck with finding somewhere for children to go to. You have to stop and go. That's going to depend upon what availability is in other English medium schools in the area. Or in English medium primary schools, did we tell again in English? Okay. So that's what you say, is that's consequences, your submission, not equal definition.
And the fourth point concerns 1.9, but was 1.9 was principle. And I say 1.9 wasn't the principle, it was the only. And my learned friend says, well, it was a suspicion of procedural irregularity that should have been raised with the judge at the time. And the answer to that is, we didn't know that there was an issue at all with the Bwrdeistref claim until we got the written reasons for refusing permission to appeal. So, it wasn't possible. As far as facts are concerned, I rely on everything I said yesterday. I don't. One tiny point I should have raised, which is my Lord Justice Lewis was asking yesterday what is a middle school.
Oh, yes.
And a middle school is defined in Section 5 of the Education Act of 1996, a school which has been established to provide full-time education to requirements of pupils who are A, attained a specified age below 10 years and 6 months, and B, or under a specified age above 12 years. So it's basically would be a number of different ages within it. For each 19 would be 8 to 13.
But we'll take time to consider a decision and judge this and hand them down in the usual way, and the second will be electronic, which will give you an opportunity to suggest epigraphically. It would be helpful if you were able to agree with the suspension orders that need to be result of judgment, because if you're not able to read them, then we will deal with those matters in writing, and you should exchange permission as efficiently as you can. If you need direction to do that, we will give that to you. There only remains me to thank all counsel and solicitors who have thought they have listened to the stream for their very efficient preparation of the case and helpful arguments that we received. We do with great pleasure. The city